Uh, Members of the House, several months ago, on October 16, 2007 to be exact, the House passed the Foreign Intelligence Surveillance Act legislation known as the Restore Act. In view of this member, the Restore Act was a reasonable and balanced one, giving the administration the power it needs to combat terrorism while protecting our precious rights and liberties. The legislation before us today, which I concede includes significant improvements over the Senate legislation, goes beyond what I think was a reasonable bottom line in the form of the Restore Act. Title I of the bill continues the House approach by providing mechanisms to ensure that FISA's long-standing exclusivity is crystal clear. It states only a new statute directly addressing the executive branch's Foreign Intelligence Surveillance Authority can modify FISA. Secondly, it provides sunshine by requiring that the government requests to private parties for surveillance assistance must actually cite the statutory authority under which they are issued. Now, in earlier versions of FISA reform, the administration claimed that prior court approval of procedures for overseas surveillance would hurt national security. This matter is now laid to rest with a consensus that upfront court review is indeed appropriate. The requirement for individual warrants and probable cause determinations for Americans overseas is an improvement over even the original FISA legislation. There's a provision in the legislation that permits the Attorney General and Director of National Intelligence to begin a surveillance prior to seeking court approval for the necessary procedures in exigent circumstances. This is intended to be used rarely, if at all, and was included upon assurances from the administration that agrees that it shall not be used routinely. The measure before us further requires extensive oversight by Congress and the independent inspectors general to prevent abuse. It mandates guidelines for targeting, minimization, and to prevent reverse targeting, and task the inspector generals to monitor compliance with those protections. Now, Title II of the legislation concerning telecom liability raises the most serious concerns in my view. In the past, I've said I've been open to developing a set of procedures that allow both plaintiffs and defendants to make their case. Unfortunately, this bill goes well beyond that and changes the substantive standard for legal liability by the telecom community, by the telecom companies, and does so on a retroactive basis, retroactive immunity. And so I appreciate that the final bill does not send the matter to a new secret court and does grant the court a meaningful role in the determination. Unfortunately, these improvements do not redeem the overall provision. In Title III of the bill will also ask the inspectors general to conduct independent investigations into the President's warrantless wiretapping program. This inquiry will help uncover the truth for the American people, hopefully, about the President's activities. And then there's a part in here about a week that an emergency provision, any U.S. citizen can be wiretapped, and I strenuously object to that.